Good morning, everyone. I'll just allow a couple of minutes for technology to get everyone in the room. Welcome to our first webinar of 2021. I'm Angie Crush and I'm a partner here at Thomas Mansfield. And today I'm joined by my colleagues, Julie Goodway and Jonathan Mansfield.
Hello.
Now, Thomas Mansfield, we're a specialist employment law firm and we work with a wide range of employers, often with HR managers and their teams, but also with businesses who perhaps don't have a separate HR function. We also regularly work with HR consultants who, from time to time, need backup or sounding board on the trickier cases they might be dealing with for their own clients. Now, today's webinar focuses on an issue that we spend a considerable amount of time dealing with. That's disciplinaries and performance management. Now, disciplinary and performance management processes are not the same thing, although certain elements are shared, such as the need to have sort of robust processes, a series of meetings, etc. And what we're going to do today is we're going to spend the first section of the webinar going through disciplinary procedures and pitfalls, and then we're going to look at the differences between that and performance management. On your screen, you'll see some buttons, including a chat box. If you have any questions during this webinar, please write your questions in the chat box, and I'll try to get these answered at some point during the webinar. And there's also an offer box, which we'll tell you a bit more about later. And you'll also see there's a files box, which if you look in there, we've prepared a PDF with sort of common pitfalls in conducting a disciplinary. You can download that file and keep it for future reference. So the four main stages of a disciplinary process are, firstly, thinking about possible suspension. Secondly, investigation. Thirdly, disciplinary itself, the actual disciplinary hearing. And then finally, there may be an appeal process. Now, before we start the nitty-gritty, I'm just going to publish a poll. So you'll see that there's a polls box. And what I thought I would ask was, when's the last time that you have conducted a disciplinary hearing? Is it within the last 6 months, within the last 12 months, or is it more than 12 months ago and so you might be a bit rusty? If everyone can just answer that poll, and then we can just see, you know, it also gives us a feel for how often you're dealing with these things. You know, obviously we only see clients when they have got an issue. So it's useful to know, you know, how often you are dealing with this on a daily basis. And looking at that, it seems that actually, you know, vast majority of you, 2/3 of you, have had a disciplinary to deal with in the last 6 months. Some lucky ones, you know, 1/3 of you, the lucky ones, haven't had to deal with one for more than 12 months. So that's good news. But at least it shows that I'm going to end the poll there, that the subject matter we're covering is definitely relevant, because definitely a lot of you are dealing with these on a regular basis. So Julie, one of the first considerations that an employer will have is whether to suspend the employee prior to an investigation and a disciplinary hearing. So can you explain when it might be appropriate to suspend?
Well, I think, first of all, the key phrase that you're going to hear a lot throughout this webinar is the need to act reasonably. And that applies equally to suspensions. Now, I'd say it's probably less likely that you're going to be considering suspension simply because an employee isn't performing as well as he or she should. But it certainly may be something appropriate to consider where there's an allegation of misconduct. Now, I tend to find that when there is an allegation of misconduct, an employer's knee-jerk instant reaction is to want to suspend. But that can be a mistake because, well, you need to consider, whether suspension is appropriate in the circumstances. Is it reasonable? Now, it may be appropriate to suspend when there's a potential threat to the business or to another employee, or also if you're concerned that that employee, by remaining in the workplace, may somehow interfere with your investigation. But maybe before suspending, things to consider will be, well, could you, instead of suspending, move that employee to another part of the business for a short period of time, or maybe requiring them not to have contact with a particular employee? Now, if you do suspend, then do so with pay. It's only in very rare situations could you ever do so without pay, and that would be if you do have a contractual right to do so, and even then use it with care. And the other key thing here to take away about suspensions is that always keep it under review. Only suspend somebody for as long as is necessary.
Okay, thanks for that. And I also find with suspension, one of the tricky areas is how you communicate someone's absence to the rest of the workforce. It needs to be handled very carefully to avoid the risk of claims if they consider that their ability to return to work, with a clear record, as it were, has been compromised in any way by what's been communicated to the team during their absence. So it really does require care. Now, the next step would be an investigation to decide whether the matter should go to a disciplinary hearing. And most of the time, an investigation will be necessary for the employer to go through. But Judy, sometimes an employer can be faced with an employee who just admits an allegation immediately. In that situation, does an employer still need to go ahead with an investigation?
Well, I suppose this is like the golden nugget for the employer. Certainly the investigation is likely to be much more straightforward, but my advice is still to investigate. And the reason for that is because you may find during the investigation that the employee gives you some mitigation. They may say about how their health has affected their performance or is a reason for their misconduct, or even perhaps that maybe one of their colleagues told them to do such and such misconduct. So they're all things that you would find out if you do a proper investigation. So my advice is do the investigation, and as appropriate, if you feel it's necessary, then to go through with a disciplinary hearing as well.
Okay. And Jonathan, so the employer has completed the investigation and decided that there is sufficient evidence there to take it forward to a disciplinary. What steps then need to be taken to prepare for a disciplinary hearing?
So if you're overseeing the disciplinary procedure, this is a good opportunity to have a double check to make sure that procedure is being followed. Recheck your own procedure. Of course, if it's been professionally checked in the past, it will comply with the ACAS code of practice, which is a kind of bare minimum. You'll need to be looking at who is going to take the hearing. At this point, you want to have somebody who is different from the investigator. So usually each stage of the procedure, investigation, hearing and appeal, you want to have somebody different and usually more senior, especially when you're going up to appeal level. You want to make sure that the process is going to be completed within time scales. The ACAS code says that unreasonable delay should be avoided in disciplinaries. And there can be some particular issues to consider, such as whether a reasonable adjustment should be put in place, say if an employee has a disability, or perhaps if an interpreter is necessary because of language issues.
And what about more generally in sort of in the invite and the charges that are put to the employee? What steps should an employer take there?
Well, formulating the allegation correctly in the invitation letter is one of the first things, and one of the things which employers have often slipped up on. A good example is the case of Celebi and Scholarist Compass UK, which was held at the Employment Appeal Tribunal to be an unfair dismissal, because the invitations to hearing and the outcome letter itself said that it was about misreporting of stock figures, not following financial procedures correctly, and discrepancies in banking. However, in the dismissal letter, it referred to a reasonable belief that the claimant had stolen £3,000. That was also in the witness statement at the tribunal hearing. But an allegation of dishonesty had never been put to the claimant, and it was found to be an unfair dismissal. As well as framing the allegation with precision, you also want to make sure that all the evidence is provided, all witness statements that have been collected and any written evidence provided to the employee well in advance, so that they have the opportunity to digest them and make the relevant submissions on them. I think another thing that's important is to keep the evidence under review, because it may be that the investigation has led somewhere else, which means that the allegation is not perhaps what you thought it was going to be when you started the investigation. So respond to what's actually been found in the investigation process in a dynamic way.
I think that's really important, isn't it? Because sometimes what will start off as one allegation, something else will come up during the course of it, or the person hearing the disciplinary might decide, well, actually, this is misconduct, but it wasn't in the original letter. It's really important to make sure the employee is kept updated about what is currently under consideration and what the charges currently are, so that they understand they need to respond to that if necessary. And another thing I would say, a sort of tip, would be that I can't emphasize how taking a little bit of advice at that sort of disciplinary stage can pay dividends if you ever end up in tribunal later. For example, adding a more general allegation, such as the employee's behaviour has caused trust and confidence to break down, can give an extra option to employers if it comes to tribunal. That in itself could be some other substantial reason to dismiss someone, so that even if the allegation, the original allegation isn't necessarily proved to the satisfaction, it may be that just that the overall behaviour is such that you think we can't have this person working there. And at least it gives another option to employers under a different section of the Employment Rights Act. So I would always say take advice at that stage, because that's the point where you're really, have to get things right, because you're going to be relying on what you did then later in tribunal if the employee ever takes a claim. And now, typical problems that can arise during the process. What do we do, Jonathan, with the employee that raises a grievance during the disciplinary process?
Yes, well, I mean, sometimes it's true that this may just be a tactic on the part of the employee to delay the process, but obviously you have to treat it carefully. There isn't a clear-cut principle. Even the ACAS guide says in some cases temporary suspension of the disciplinary process may be appropriate. So no more precise than that. It does in the guide that's attached to the code. There are some examples they give, such as where there is a conflict of interest with the manager who's hearing the investigation, or if management has been selective. So it's very focused on the way the evidence itself has been gathered, or if there's possible discrimination. But even there, it may be that you can argue that it will be possible for them to put forward the points that they have concerns about in terms of the investigation, to put them forward in the disciplinary process itself. So it's not certainly not clear cut. And indeed, case law doesn't say that there's a general principle. I mean, there was a case, Samuel Smith, Old Brewery, Tadcaster and Marshall, where the Employment Appeal Tribunal has said that it's not a general principle that you must suspend the procedure. And another case more recently involving Dockland buses, Jinadu and Dockland buses, the EAT again repeated that point, that it's not a general principle that you must. It does depend on the circumstances, though, because you can see how sometimes it might be the case. I mean, there was a case involving a culpability situation where the conclusion of the grievance was crucial to whether the employee could return to work, and because that went very much to the core of the issues when it came to the decision making, there the grievance should have been carried through.
Thanks. And the other scenario we often see is an employee going on sick leave during a disciplinary process. Sometimes as well, some maternity leave might come up during one of these processes, but more commonly it's the employee that goes off sick. What should employers do in that scenario?
Well, just because somebody is not well enough to work in their normal job doesn't mean to say that they can't attend a disciplinary hearing. And, balancing things here, a disciplinary process shouldn't be subject to undue delay. And there's a conflicting priority if the employee puts forward the idea that they cannot attend. But rather than just simply accepting that, look at ways to help them attend, perhaps organising the hearing remotely, perhaps easier idea for people to get used to in the Zoom age. But even in normal times, perhaps off-site, organising the meeting off-site, maybe looking at the question of who accompanies that individual and making an exception and allowing a family member. So all of those are worth looking at first. If the employee still insists that they can't come because they're not well, you might want to actually refer the matter to occupational health or get another medical report and ask the specific question as to whether their illness means that they cannot attend a disciplinary, which is, as mentioned, a different question. You could also ask the question, what are the consequences of the disciplinary being delayed? Because often it's the disciplinary itself. So if it's stress, which of course is, well, I think it is the most frequently cited reason for being off sick in that situation, it may be that resolving the disciplinary will mean that individual can return to work. So that question could be asked as well. What are the consequences of undue delay of the disciplinary on their health? And then just final point on, reasonable adjustments can come up if there's a disability. And I've mentioned, the possibility of who accompanies that person and, taking breaks, precautions to make it less stressful than it often might be in a hearing. And
there's always that sort of last resort of just asking them, if you think we've got to go ahead with the hearing in their absence, ask for written representations for them to be considered, if you are going to go ahead with the hearing anyway. And I think just going back to your point you just made, there is some research, some medical research that actually says that the best way to alleviate the stress is to deal with what's causing the stress, i.e. the disciplinary itself. And so, I often use that when going back to employees or GPs who perhaps are signing people off sick to say, well, there's this research, do you not think that this would actually help the employee to attend the meeting? That can be quite effective. You mentioned being accompanied by a family member. And again, it's something that employees ask from time to time to bring a family member or sometimes a friend. When might that be appropriate to allow?
Yeah, so most company policies will just follow the statutory requirements, which is a fellow employee, trade union full-timer, or a certified trade union representative. But cases where perhaps there is a disability, or the kind of examples I've given just now about where they're suffering from stress, might be situations where you would consider that they need support, but particularly if it's a reasonable adjustment because of an actual disability, most likely.
Okay, so moving on to the hearing itself. Now, since the pandemic, we've seen a bit of a change in how these things are commonly conducted, and with the advent of Zoom and Teams, I've seen a bit of an increase in employers just recording the meeting because it's easier, and no one's sitting there taking a note. I'm going to do a poll just to ask, sort of going forward with everyone watching, what do you think you'll do with disciplinary hearings, whether it's by Zoom or when we go back? Will you just start recording them rather than trying to take note? And it's yes, no, or not sure are the options, and then Julie's going to talk a bit about this area. So it seems that the preferred option is still not to just make a recording of them, although it's changing a bit. And probably just over half, so 52% are not sure what they're going to do going forward. Maybe they're waiting to hear what Julie's got to say about it. So I'll end the poll there. Only 16% are a definite yes, 30% are a no. So I'll end the poll there and ask Julie. Julie, what do you think about recording these meetings?
Well, I suppose the traditional approach has always been to not audio record a hearing and instead for written notes to be taken. I'd say that for performance management meetings, keeping a written record is probably still the way to go. I don't see that there's really a key need there to audio record. But for disciplinary hearings, I think that there are some advantages to audio record. The main one is that it shows you've got nothing to hide. It shows you're very confident about how you're going to be conducting the process. The other benefit is that you've then got a record of what was said, so it avoids any issues about was this said, was it not said? There's a proper record there of it. I'd say as well, it probably could also help to avoid maybe an employee covertly recording a hearing, because if it is covertly recorded, then you've got no control over it, and who knows where it might end up, perhaps on social media, which is not what you want. But there are also disadvantages of audio recording. The main one is that if the disciplinary chair mucks up, then there's a proper record of it. As a result of that, I suppose it could make the disciplinary chair more nervous, and that's something again that you might want to be avoiding. I suppose the benefit of having a handwritten record of it is that handwritten notes tend to be not verbatim, and so do tend to be more concise. Whatever you do decide to do, and certainly if you do decide to audio record, then just make sure that you inform the employee and their representative at the start of the hearing so that they're aware of the situation.
Thank you. And a little side note and a warning on this topic, in case anyone hasn't come across it already, is that if you are recording any of these meetings, I mean, whatever they're about, it could be redundancy, it could be disciplinary, on the Zoom and Teams type technology now, I've had 2 cases since lockdown that have come to me where if you have breakout rooms, which you can do in these online things, those bits are also recorded. And so if you then send someone the recording after, they will get the breakout room. So I had one case where an employee and their companion were conferring, and the employee sort of admitted some things that he hadn't admitted in the hearing. And when the employer watched the video back at the end, when they were sort of making their decisions, they saw this conversation, and obviously the employee wouldn't have wanted that, but it was there. That was how the technology works. And similarly, I had a situation where the employer was speaking to their HR rep in the breakout room, and again the video was sent to the recording was sent to the employee without anyone having watched it, and it transpired that the employee would also have seen that conversation. So the point here is beware and watch the recording before you send it anywhere, because you really don't want to be caught out there. Now, Julie, what happens if the employee goes ahead and takes a recording covertly anyway? What should the employer do?
Well, I think the first thing is that if you want to try to prevent this, then make sure that your disciplinary procedure specifies that it is forbidden. But also, in any event, at the start of the hearing, tell the employee that they're not allowed to record it. Ask them to confirm that they're not recording it and that they won't be recording it. If they then go ahead and record it, then that's a disciplinary matter, and you could take disciplinary action against them as a result. But I suppose be aware that the employee may still go ahead and covertly record that meeting, even though it's an act of misconduct. And you're then in a situation whereby, if it ever did get to an employment tribunal, what has been said in that covert recording could be evidence, admissible evidence, and that can include even the recording of, say, the private panel discussion. And there are some interesting cases about this where it has been held that those private recordings of the recordings of the private chat by the panel members is admissible, and that's really where what has been said during those private discussions goes to the heart of that person's case. So be aware of that.
And we had an interesting comment from one of the viewers saying that, having got fed up basically with employees challenging the notes and using the notes tactically, that they're in favour of recording hearings now because there's just no scope for any confusion. And I think a lot of people probably might take that view if they're confident in that the people know how to deal with the hearings. We'll come on to the notes in a moment, because I'm going to ask Julie about that. Talking about covert recordings, I think the tribunals, I don't know if anyone saw the case, but there was an employee who had been going around work making various covert recordings, not in a disciplinary hearing, but the tribunal certainly showed their contempt for employees doing this as a matter of practice, and made a costs award, one of the highest costs award made, £432,000 against an employee last year, where they'd been going around covertly recording, bits and pieces here and there. So, I think the tribunal aren't that happy about it, but as Julie says, they will be admissible in evidence a lot of the time. Now, one other aspect in hearings that we come across from time to time is cross-examination of witnesses. I saw a case recently where the employee wanted to call about 30-something witnesses to cross-examine. Should we allow, should employers be allowing employees to cross-examine witnesses, Julie?
Well, first of all, looking at the ACAS code, that does state that an employee can be allowed and should be allowed to call relevant witnesses if they wish to call them, and given the opportunity of raising any points about the information that witness is providing. But we also have to remember that a disciplinary and performance management hearing, these are not some form of quasi-judicial hearings. So ultimately, whether it's appropriate to allow cross-examination will depend on the circumstances. And of course, it's always important for the employer to act reasonably. Now, I'd say it's probably perhaps worth just looking at a case relating to this. And the case here that I'm thinking of is the case of Lewis against a governing body of a Welsh primary school. Here, the teacher was accused of mishandling a pupil. And there were two of her, turns out to be her ex-colleagues, that had given written evidence about this. Now, she asked for these individuals to be called as witnesses, but they didn't attend the disciplinary hearing. And it turns out that really the school didn't really encourage them to attend. She was subsequently dismissed, and she brings an unfair dismissal claim. And here the Employment Tribunal does say, yes, she was unfairly dismissed because it wouldn't, under the circumstances, it wasn't reasonable for the employer simply to rely upon the written evidence of these two witnesses, and they should have taken steps to encourage them to attend. Now, clearly they can't be forced to attend, but at least they should have been encouraged to attend. So I suppose this is just a reminder that particularly when somebody's job is on the line, and potentially as well their career is on the line, that it is important to act reasonably in terms of making sure that certain witnesses are encouraged to attend. But there can also be a situation when a witness does feel very intimidated to attend. And here I would say that it may be sometimes appropriate for the employer maybe to be the one that does the cross-examination, find out the questions that the accused wants to put, and then for the employer to put those. Just to perhaps give a personal example that I've had of this, I was once advising an employer where the accused had threatened a witness. He threatened to hit her in the face with a club hammer made of nails. He was a member of a notorious Hells Angels group, and he was very proud and open about it. So understandably, in those circumstances, he was not going to be allowed to cross-examine that witness. It did go to the Employment Tribunal. The Employment Tribunal was very sympathetic towards the employer, and that individual was found to have been fairly dismissed.
And I think it's examples like that show you why we do our jobs, because it brings a fresh surprise. We've had a question come in. I'll perhaps ask Jonathan to give you a breather, Julie. In what circumstances might it be appropriate to continue with a disciplinary hearing if an employee resigns with immediate effect before the hearing? And I'd first of all say that there's probably two answers to the question. One for FCA or PRA regulated type hearings, and one for perhaps everyone else. Because I think if you're regulated by the FCA and you have regulatory standards and you have appropriate persons and you have all that financial management and self-regulation, which means you must get to the bottom of any sort of allegations against someone, you probably need to go ahead with the hearing anyway to be fulfilling all of your obligations to the various regulatory bodies, because obviously it will come into referencing and all of that sort of thing, and you'll need to say, is this person fit and proper and all of that stuff. So I think if you are in a regulated sector, you may not be able to just say, thank you, I'll take that resignation and I will run with it. But what do you think in other companies, Jonathan, that perhaps aren't regulated? Do you think the employer's okay to just say, okay, I'll take that? I mean, I guess there's questions of notice pay and that sort of thing.
Yes, I think most employers in that situation will take a pragmatic view and I think in the majority of the cases they probably won't go through the disciplinary process, but they may feel that it's necessary for other reasons, that the investigation is seen to come to its conclusion as a matter of policy within the organisation, certainly if they've got to decide on the question of notice pay. If the employer resigns with immediate effect, then that perhaps won't come into it. But no. And it may be that agreement can be reached upon that as well. But it's only, it's in the regulatory sectors that you'll want to. Regulated sectors, the CQC may be interested if it's the health sector, for example, as well as you mentioned the FCA. Yeah, and I think, I think actually most employers would just take the resignation, if they can. But there is, of course, that, employers should be thinking, well, how did this be allowed to happen? Say it was a sexual harassment allegation or something. Yes. And then they may, they probably should be trying to find out how this could have been allowed to happen, and do they need to make their policies more robust or something, or training? But I imagine most will just take the resignation. Yes, and in that case, of course, it may have some impact on if there was a discrimination claim, arising out of the harassment, how they responded to it could affect things like, say, an injury to feelings award. If they just simply brushed it under the carpet. There's a funny anecdote just come in from someone saying they worked in a regulated business many years ago, and an employee asked for an adjournment saying he needed some fresh air, and he went out, never came back, and left a letter of resignation on the receptionist's desk. Well, he probably could tell how that hearing was going, I'm imagining. Julie, going back to the issue of notes on disciplinary, we often see all this to and fro over the notes, and I didn't say that, or I said this. Do they need to be agreed with an employee?
I would say no. Certainly do send the employee a copy of the notes and ask them for their comments on them, but seeking their comments is obviously different from seeking their agreement, because seeking their agreement, as you say, can lead to this toing and froing, and they possibly never get agreed. Now, if give them a deadline as well by when you want those comments back by. If you agree with any of the suggested amendments that the employee wants to request, then you can add those in, but otherwise just append their comments to the back of the minutes, and that's it. Okay. And Jonathan, so we've had the hearing, all of that's been done. What factors are relevant in the decision-making process to decide on the appropriate disciplinary sanction? Certain factors that should always be taken into account. One of them will be the length of service of the employee. Of course, it's going to be highly relevant as to whether they have the qualifying service for unfair dismissal, 2 years at the moment. But it's also a general consideration especially where dismissal is being considered. You'd also want to look at the prior record of the employee and whether there are any warnings on file. And I do stress the word also, that live warnings, because employers have certainly come unstuck trying to revive historical or expired warnings as well. I think the attitude of the employee is a relevant factor here as well, because if they accept that their behaviour was unacceptable and show commitment to improving in the future and avoiding repetition, you might be viewing them very differently to somebody who takes no responsibility, maybe argues with management, or says that there's a conspiracy against them to accuse them falsely or something like that. And what about where there's conflicting evidence? How should an employer deal with that when they're making their decision? Well, it's important to be careful, to tread very carefully on this, because there is case law which says that if you make
an inference that just because someone has no reason to lie, that you can prefer their evidence, say, over that of the accused, that there is case law which says that isn't sufficient reasoning. That's the Salford Royal NHS Foundation Trust and Roldan case. And it was observed that an employer faced with conflicting evidence does not always have to decide that it believes one person over another. But I think if you're trying to make that decision, you'll need to look at the broader evidence, maybe inconsistencies within that evidence, and also documentary evidence to reach a decision. Sometimes you might not even be able to decide, which obviously is a difficult situation to be in. But it didn't help in that particular case that the notes taken when they interviewed the accuser were much more detailed than the scanty notes on the evidence for the accused. But it was an unfair dismissal in that case.
So, $1 million question, Jonathan. What sanctions are appropriate? How does an employer decide what sanctions are appropriate?
Well, so employer has to reach a conclusion on the balance of probabilities after a reasonable investigation as to whether the employer is guilty of the misconduct, and I should say the misconduct which has been put to them, not something else. Just having followed the fair procedure is not going to be sufficient. And of course, a dismissal for first offence is not going to be fair unless it's, gross misconduct is possibly complete breakdown of trust and confidence, but gross misconduct is the usual one. Otherwise, there will have had to have been warnings up to a final written warning. Some disciplinary procedures will allow employers to jump stages if it's a more serious offence and jump in at a final written warning straight away. But caution needs to be applied. There's case law, Alexander Russell, PLC, and Holmes, where warnings, especially final written warnings, used oppressively and for relatively minor offences could actually be found to destroy trust and confidence and actually lead to the employee justifiably resigning and claiming constructive unfair dismissal.
And I have to say with this that I can't emphasise enough how important it is to take action over all conduct matters and not letting them build up until you want the employee gone. Because if at that point they aren't already on a final written warning and they haven't committed gross misconduct, then you probably can't fairly dismiss them. We see so often, HR managers at their wits' end because their managers haven't been using the policy that they have in place to discipline over time when the smaller things have occurred. And then the manager just goes to HR and says, right, but this person, they've done this, we can't have it anymore, they've got to go. And of course, the HR manager doesn't have the tools at their disposal to fairly then sort of take action over that in a way that could dismiss. So really, it's so important to make sure your managers are properly using the disciplinary process whenever it's right to do so. And on this, I'm going to just publish a poll. This is certainly my experience with HR managers, seeing that their actual managers aren't, implementing things properly. So I'm going to ask who feels confident about their managers conducting disciplinary hearings. Who feels confident that they know exactly what they're doing when they are conducting disciplinaries? And either they know exactly what they're doing, you don't have to sort of guide them. Some will think they know what they're doing with some guidance. 22% at the moment say no, they're not confident that they know what they're doing. And and then there's a small majority that say no, it is a bit of a liability, and it is a risk factor for the company, because ultimately that that sort of lack of knowledge of has two implications. One is that it means the company is at risk of claims if the disciplinary goes wrong. But secondly, it means that the company just can't actually get around to dismissing someone who keeps underperforming, because the manager doesn't have the confidence to use the process in the first place. So that's quite interesting. No one says that the managers know exactly what they're doing, but there's about half and half that say they know what they're doing with some guidance, or they're not really that confident that they know what they're doing. So that's interesting, and it sort of bears out, I think, my general experience in dealing with employers. So what about mitigation? What sort of things could be taken into account in relation to mitigation?
Yeah, well, first I would say that make sure you do give the opportunity to the individual to put forward mitigation at the end of the hearings in those natural time. Examples could be lack of training or guidance relating to the exact reasons for the offence. For example, there could have been a breach of health and safety, but the serious consequences weren't properly appreciated. Unreasonably, they weren't properly appreciated by the individual employee. A disability or a mental health issue could also be relevant. And in some cases, it might be appropriate to treat the decision itself, say a decision not to dismiss but to give a warning, as the reasonable adjustment in a case with a disabled employee.
And also with mitigation, it's really important to remember to actually mention it in the outcome letter. Say that this or that's being considered and taken into account in deciding on the sanction. It's really important that you say what's being considered. Similar point applies to if you've considered a lesser sanction, which everyone should be considering. Could I impose a lesser sanction? And then say in the outcome letter, I considered doing this, but I disregarded it. Really important to say everything that's being considered, because there's far less scope to challenge if you do that. So we've had the hearing, we've had the sanction, the employee isn't happy and they want to appeal. Julie, does it matter who hears the appeal?
Well, unless it's a firm with just like a one owner or one manager, then it is important that the person conducting the appeal is impartial and that they haven't been involved previously in the earlier stages. So do at the very outset, before you even start any investigation, start thinking about, well, who's going to hear the investigation, who's going to be dealing with the disciplinary hearing, who's going to be hearing the appeal. The person that does deal with the appeal should ideally be more senior to the disciplinary chair, or at least be their equal. Don't be using somebody that is more junior, because otherwise there can then be a suggestion that that person is then just deferring to their superior. It can also be a good idea to even use somebody to hear the appeal that is outside of their employee's department or area of their business. Again, it helps to avoid any suggestions of bias. It's probably also worth remembering that if you do fail to do an impartial appeal, it could give rise to a claim that there's been a breach of the implied duty of trust and confidence, such to give rise to that person resigning and claiming constructive unfair dismissal.
Thanks, Julie. Just to answer a question that's come in, does recording of hearings mean you don't need to have a witness with the person running the hearing? So just to be clear, the employee will always have the right to have accompaniment by a trade union rep or colleague. On the employer's side, the person, usually you'll have the person dealing with the hearing, and then there might be a note taker. If you are recording it, then you don't necessarily need the note taker there. So yes, it does avoid the need to have a note taker there. Often the note taker will be someone from HR, which means that if necessary, they can confer and ask any questions that they need. But yes, there's no requirement for an employer to have someone else there, but as a matter of practice, they usually do, and recording it would dispense with that need. Jonathan, in summary, what are the most common mistakes that you see employers making dealing with disciplinary procedures?
Well, I suppose first thing is there's a little knowledge is a dangerous thing type issue which comes up with the 2-year rule on unfair dismissal, assuming that it's okay to dismiss just because they got less than 2 years. First of all, a small technical point, it's not really 2 years because it's 2 years less 1 week, because the 1 week statutory minimum notice can be added on to the amount. And I have seen employers come unstuck who think, the 2 years is coming up, let's act, but it's only 2 or 3 days before, and they get caught. And of course, apart from that, there are situations where dismissal will be unfair anyway, where they're protected if the reason is related to whistleblowing allegations having been made, or issues about health and safety, or if they're a health and safety or trade union representative. And of course, there's a possible substantial claim if discrimination, an allegation of discrimination could come up, that the dismissal is for discriminatory reasons, and then the employee will still have a substantial claim. Other common mistakes, I would say, are failure to interview relevant witnesses, a bit of a tendency to interview the management witnesses for the management case, but what about the ones who might exonerate the employee? Also, the assumption that an employee knew about a rule or a procedure. There have been a number of unfair dismissal cases involving things like internet, accessing porn on the internet, where the dismissals were unfair because it wasn't in the internet policy that people could not do that. And the other thing I think you'll see is failure to provide all the evidence to employees before a hearing.
Thanks. And one other area which can sometimes lead to problems in tribunal, how involved should HR be in the process and in determining the outcome, if at all?
Well, I think the answer to this question depends partly on the sophistication and level of training of the managers involved. And generally speaking, it is good practice to have HR involved in overseeing, making sure that the ACAS code is followed, making sure that the procedure is followed. But the managers who conduct the investigation, and above all the decision makers, need to take full ownership of the process and the decision making, and not just relying on the HR manager. So it's a kind of balancing act for the HR people, because you clearly want to have people coming to you for advice on the best steps to take, but at the same time they need to be thinking for themselves, because they're the one who's going to have to get up in the tribunal and defend the actual decision. And in practical terms, one of the biggest risk areas for employers is with line managers who are not HR professionals conducting investigation and disciplinary appeal without being properly trained at each stage. It's easy to make mistakes and say the wrong things, and certainly it's very advisable to have training in place. Another thing which is frequently seen is an investigation report which is somewhat biased, doesn't realise that it's meant to be an objective gathering of evidence process. It's very skewed and perhaps influences the mind of the person who makes the hearings.
Okay, so really your recommendation from that is to ensure that the line managers and the managers who may have to conduct these hearings are properly trained. And so this takes me back to something I mentioned at the start, which is that we have an offer that we're making available to everyone watching today, which is, because we see manager training as key to these processes, we're offering our half-day bespoke manager training course on how to conduct a disciplinary for the discounted price of £800 plus VAT. That's for up to 12 participants, and we can conduct that over Zoom for your managers. And we'll go through all of the things we have today, but in far more detail, and also do some actual case studies, do some practical work with those managers so that they get a bit of practical experience in dealing with it. You know, how would they question someone? How would they deal with an employee who doesn't want to answer the questions or whatever? If you register your interest for this today, as I say, we're offering 20% off. We would usually charge £1,000 plus VAT for that half-day course. In the offers section at the side, or wherever it is on your screen, you'll see there's a button where you can register your interest now, and also our emails are going to be put in the chat, so you can just, if it's easier for you to just email one of us direct, you can do that. And I think the file that we shared with you earlier, that also has email addresses on it, so you can email us. If you register the interest today, you don't have to at 100% get it all sorted today, but we will honour that offer for you. So moving on to differences, I'm conscious of the time, but moving on to the differences between disciplinary and performance management. I mean, there are key differences. One's more of a won't do, one's a can't do. And it's far better to have a separate process for both. Because whilst performance management can result in warnings, that a performance management process should be far more supportive, designed genuinely to improve performance, and dismissal is an absolute last resort. So we're just going to look at a couple of tricky areas. The most common question is, how long do we need to give a poor performer to improve? You know, how long before we can sort of dismiss someone who's not performing? Julie, what would you say to employers on this?
Well, firstly, if you do have a capability procedure, then that may set out the time scale. Then if so, follow it. Certainly don't do any less time than that. Otherwise, there's no real hard and fast rule. The ACAS code, though, does note that you should give at least 2 warnings before somebody is dismissed, unless you're concerned about gross negligence, gross negligence. Normally, though, you're looking probably at about 3 to 6 months for the whole process. That's from the start, and obviously during that you'd be giving reviews, you'd be giving warnings, so 3 to 6 months from the start to the very end. But it depends on the circumstances, it depends on a number of factors: the person's seniority, the role that they're doing, any performance issues in the past, what impact as well is their performance going to be having on the business. So lots of things to consider. Now, I could go into a lot more detail about various things about poor performance, but I'm conscious of the time at the moment. Just a couple of things, therefore, just to note: when you're setting targets, make sure that they are SMART. We all know what that means: specific, measurable, achievable, realistic, timed. Also, make sure that you are reviewing and constantly monitoring that performance, and also think about, has the person had the relevant training as well?
Okay. And any more general tips you'd give an employer dealing with a performance issue?
I think the first thing is, don't delay. Basically, if you are aware of any problems, look to nip it in the bud. I see very often, line managers perhaps are a bit nervous about raising performance issues with somebody, so it doesn't get raised until the annual appraisal. That's not good for the employee, it's not good for the business either. Give them an opportunity to improve, and hopefully they will make improvements. The other key thing I would say is that keep a written record of everything, and just be consistent as well in terms of your approach to the handling of any matters. Thank
you. So we'll wrap up there. Thank you for joining us. We hope that you've enjoyed it. Please, as always, give us your feedback. We are also continuing to offer to have, we haven't had time to go everything we would have liked to today. So we are offering to have a free sort of half-hour consultation if you want us to look at any of the issues we've discussed today, maybe discuss your policy a bit more. The offer's in the box now, but again, just email one of us and we'll be happy to arrange that consultation with any potential new clients that might want to have a conversation with us. Hopefully that's been helpful to you all. Our next webinar is on the subject of settling employment disputes. That's on the 11th of March. It's a real practical area, how you resolve disputes with employees, settlement agreements, exit discussions, all of this sort of thing. And so it should be a good session. So we hope you'll join us for that. Do sign up at our website. There's a question about if there's recording of today's training. Yes, all of our webinars, all of our previous webinars as well. If you go to the Thomas Mansfield website, there's a training and events page and you can watch all of our webinars on there. It usually takes about a day for it to get online, but absolutely you can watch it all back through. So thank you for joining us, everyone. I'll end it there and say goodbye, and hopefully we'll see an end to this snow. Bye.
Goodbye.
Bye.